Oh, okay, thank you. I'll call the case Mineral County Sheriff Ryan Funk versus Mineral County Commissioners. This is DB 23-37, a Mineral County case. The court is appearing from Missoula County Courtroom 1, Missoula County Courthouse. We have Deborah Jackson and Wally Congdon appearing on behalf of Mineral County, Paul Leisher and Sheriff Funk appearing for Ryan Funk, Sheriff. I have reviewed again all of the materials that have been provided. I know the parties were questioning what they ought to be doing in this hearing. I am aware anecdotally of how this has been playing out in the media. I'm well aware that Sheriff Funk is currently up for re-election, and this matter has arisen as an issue in it. I have a slight prefatory, it's a longer prefatory statement. So the case and the activities requested of the court are unusual. The court was originally asked to address two issues in the motion of defendant Mineral County Commissioners, two primary questions, and these were set out a bit in its order of December 10th. The first was whether the settlement agreement between Ryan Funk and Lake County prohibited disclosures of materials that may be relevant to Brady disclosure. To that question, the court determined that the settlement agreement did not prohibit Brady disclosures and went through an analysis of that particular provision. Then the second question, and the more thorny question, was whether materials obtained from Lake County and subject to the settlement agreement required the Mineral County Attorney's Office to affirmatively disclose those materials to criminal defendants. The court has previously analyzed whether this Brady information should be provided. The whole purpose of Brady Giglio is to make sure that defendants have adequate information upon which they can provide a defense. If any one of us were sitting in a defendant's position, we would want to know that the investigators, the people who were analyzing the case, who are going to be providing testimony, all of those individuals were doing so truthfully. We're doing so with the right motivations. We're doing so, frankly, with clarity and transparency. Brady Giglio is defendant-centered. The reality is that it has serious consequences to law enforcement personnel. We have heard, unfortunately, both in the writ of mandamus action and to some degree in this current action, discussions of, quote, Brady cop, end quote. I'm not fond of the term. I think it is a shorthand term that omits a lot of analysis. I suppose it's no different than someone calling someone a liar based upon what could be innocuous or more troubling misrepresentations. So in reviewing the court's December 10th, 2025 opinion. The court had identified three possible areas that caused it most pause. And of course, this is all material related to Sheriff Ryan Funk. And it found that two of the three areas did not require any sort of affirmative disclosure. And understand that Brady Giglio is, again, defendant-centered. It is an intent to assist defendants construct whatever case they may have to obtain a fair trial. And that means so that jurors may be aware of all circumstances under which witnesses and investigative officers may be testifying. The process of reviewing whether, let's back up. It is an affirmative obligation of the prosecutor, in this case, the Mineral County Attorney, to provide the information it believes reflects on the credibility of any witness. That could be a lay witness or it could be a law enforcement witness. So principally, the obligation is on the prosecutor, the county attorney's office. I understand the county attorney's office has asked the court, essentially, its opinion on whether the information it reviewed arises to Brady Giglio and would require affirmative disclosure. The third area that the court had found that it caused the court some concern was the investigative materials for Ryan Funk related to the March 17, 2017 investigations that were conducted by Lake County, so a county separate from Mineral, and alleged violations of certain employment manuals and collective bargaining agreements. That investigation was conducted by a different county attorney for again, different violations. And it was in the course of reviewing those, and I think the court was having trouble with some of the audio and video because of the formatting issues, and I don't recall actually having I may have had the video file. I don't know that I could play the video file or audio file. Sheriff Funk has asked the court through counsel to re-review those investigative materials and provided, copies of the audio that we're able to play. In the court, at least with the example it provided in its order, has determined that the audio and the report do generally match. That Sheriff Funk may have gotten distracted in the process of giving his giving the defendant Miranda rights, and in a short period of time while Sheriff Funk and Deputy Funk in Lake County was talking with another law enforcement officer, the defendant seemingly was answering questions that Deputy Funk was not posing of the defendant, but rather was talking to the other law enforcement officer, mainly about things like, I think a stolen coat or something like that, North Face or a jacket or something like that. And again, the defendant spontaneously started interjecting and providing information, again, not at Deputy Funk's request. Again, that was the example that the court used in its opinion, and it relied upon the investigation of another county attorney. So the court has been perplexed as how to proceed. And the reason why is this. Ordinarily, what the court does is open to public scrutiny. We don't have any public scrutiny of this process. Everything that was submitted to me in camera, and I was thrust into the position of essentially being an investigator. It wasn't subject to the rigorous evidentiary process we normally pursue in a court of law, which is witnesses take the stand, exhibits are admitted, subject to things like foundation and credibility and authenticity. Individuals who make statements like Deputies Funke's report doesn't match the audio will be subject to cross-examination. And we haven't had that. So I'm going to be asking the parties to make an offer, meaning a summary of what they think they would show. I'm not going to necessarily take testimony today. I think what the court needs to do, for a variety of reasons, and let me explain. I think the court needs to back up the process. And the reason it needs to back up the process rests on a few grounds. One, again, this process has not been subject to the typical rigors of an evidentiary determination. And it has had an impact on an individual's reputation and legal career. Again, recognizing that the court has to balance both that and the defendant's ability to know what information is out there. The process of determining those facts have not been, again, subject to the rigorous evidentiary process that the court is accustomed to. Second, and this is probably even more important, is that if the court gets it wrong, there's no record to appeal. For instance, if Sheriff Funke had not submitted his Rule 60B motion, which in a sense says, well, there's a mistake out there, Judge. Would you look at this again or reconsider it or consider some additional information? But for that motion, the other option that Sheriff Funke would have had would have been to appeal it to the Montana Supreme Court. And I'm quite confident of what the Montana Supreme Court would have done, which thrown up its hands and said, don't know. We don't have any of the information because all of that occurred on the judge's computer in chambers and with the judge reviewing it with his own eyes. And we have nothing on which to review. We can only review the order itself, which you all noticed didn't contain a whole lot of facts. It wasn't a findings of fact, conclusions of law order, but rather just simply an overview. And in part that was purposeful on my part because there are names and information. It was review of criminal justice information, which in this state has some significant rights to confidentiality. Because again, we recognize that investigations are what the case may be built upon and result in probable cause to charge. But in the end, conviction or some sort of finding of fact occurs because of what happens in the witness chair, and either the judge or the jury serving as finding of fact. So I know there's a lot of people who are watching today, and I recognize that I have taken up your time today. But in order to get this process right, I think we need to back it up. So I'm going to ask the parties, again, starting with you, Mr. Leishman, as to offer proof what you would have intended to show or what you would intend to show. And I gathered some of that from your briefing, so I'm not exactly in the dark about what you plan to show, but nevertheless, offer of proof is intended to get us to what I think is going to be the next step. So why don't you begin?
Thank you, Judge. You are correct that our presentation is consistent with the motion that I filed. And I have to note, first of all, that I was flying a little bit blind because I didn't have a copy of the materials until 6 days ago on Tuesday. In terms of what was submitted to the court, on Tuesday I received a subset of that, which was also submitted to the court. So you can see now what I had access to and reviewed all of those materials. And so my sense of the court's December 10 order was that it was only a single allegation within the 2017 Lake County investigation, which was the allegation that Mr. Funke from stated in the reports was the only piece that the court had identified out of the larger body of materials that it had concerns about needed to be disclosed under Brady. With respect to that, I was able to get some materials directly from Lake County, submit those to the court in a format because the audio recordings were in a proprietary Sony format. And Mr. Funke from the Lake County Attorney's Office was kind enough to convert that. The court also references videos, and I only received one video, and I only saw in the materials that the Mineral Co attorney submitted to me and the court this Tuesday, only one video that involves Mr. Funke that's mentioned in the 2017 investigation, and that's the video from Mr. Funke's patrol car. And so what we would present would be, first of all, the audio. I've been a little bit hamstrung too, in the sense I've had media requests, what's going on. This is a confusing situation for those of us who are law trained, very confusing for members of the public, and I've been relatively impressed with the media's ability to grasp, the core of the issue, but I can't send them the audio file showing them, here's the report, here's the audio file from the interview of Ms. Montalongo, and you can see that they match that this allegation in the 2017 investigation is simply inaccurate. There is, Mr. Funke did not extensively question Ms. Montalongo before advising her of her rights, like the investigation alleged. But so my plan today was to be able to play that, and I think the CCJI concerns are covered here with respect to balancing the public need to know versus the individual's rights. But it was to play that, to have Mr. Funke provide, there's a danger here of rehashing everything that happened in Lake County, which would take us 1-2 days, 8 witnesses. I don't think that's necessary to resolving the question here. But to provide some foundation and a little bit of explanation, who's the officer he's talking to, why is he talking to him, to explain what we hear in the audio file, to have Mr. Funke give some testimony in relation to that, to play the video file, because the allegation in the Lake County investigation was, that the video, quote unquote, does not corroborate Mr. Funk's written report. And when I played the video, there is no audio, right? The allegation is that Mr. Funk's report says that in the laser pointing incident, when they apprehended the suspect vehicle, one suspect fled, two suspects in the car. His report says he Mirandized the two suspects in the car before questioning them. And the investigation alleges that Mr. Funk that the video doesn't corroborate that. But there's no audio in the video. There's no way implication when it says does not corroborate is that it refutes, but it doesn't because there's no audio in that. And so I submitted that under seal, and then Lake County marked at CCJI, couldn't show that to the media. But it does not refute anything in Mr. Funk's report. It's not evidence that he filed false or misleading reports at all, the way the investigation suggests it is. So I wanted to play that video for people to be able to see, for the court to see. There's no audio. So it does not indicate any kind of discrepancy in Mr. Funk's reports. I also addressed in motion the allegation with respect to Mr. Funk's interview of Mr. Tenasket, and the piece that was struggling to be there was the Lake County investigation says that Mr. Funk's report says he advised Mr. Tenasket of his rights, but in fact the report shows he asked Mr. Tenasket if another officer had advised him of his rights. Mr. Tenasket said yes. And Mr. Funk asked him then, in follow-up, did you understand those rights? And he gave the answers affirmatively. Now, I did criminal investigation for the criminal defense, first part of my career. And I can't imagine that leading income and Miranda issue that would trigger, for example, a motion to suppress. The suspect says he was advised of his rights by law enforcement. And understood it, and there's an audio. One of the officers reports is wrong about which officer Mirandized him. I don't think anybody from the defense perspective who's looking out for, as the court's focus here with Brady questions, is looking out for the defendant's rights, like I used to do. Whenever make an issue out of, it was not that officer. You said you did it, but actually a different officer Mirandized him. And so playing, that audio file to show, to the extent there's a discrepancy in Mr. Funk's report, in the sense it wasn't him who Mirandized Mr. Tenasket, it was another officer. He confirmed with the suspect that officer had Mirandized him, and he understood his rights. I wanted to play that as well to show, to the extent that there's any kind of anything that I could find in this investigation that would support false or misleading reports. It's not the kind of false or misleading that suggests any kind of duplicity or attempt to, do an end run around someone's rights, or that from a defense perspective that I thought had any real evidentiary value for a defense attorney to be able to present to a jury. I did not have any information about what else the court might have been looking at, though, that the court felt, because the court's analysis of the December 10 order was, not just was Funk's conduct at any point alleged to be untruthful, biased, irregular, but those allegations are substantiated. And so my focus was on what if these allegations of the Lake County investigation are substantiated? Because the only evidence I had was that they aren't. With respect to false or misleading reports, I didn't know what else the court might have. So I had been looking at the references to other officers' reports, And so I didn't see anything in the materials that the Mineral County attorney submitted last week that, to me, substantiated any of the allegations in the 2017 Lake County investigation. But part of the reason I requested a hearing was to be able to get the court the opportunity to address other materials that the court had reviewed that or other allegations from that investigation, and then to be able to address those with the court to the extent that the court had concerns that those might be Brady information that reflected on Mr. Funk's credibility. That said, flying a little bit blinds. My sense walking in here was, these guys wanted to raise were narrowly focused on the issues in motion, or rehashing everything in Lake County, and we're going to have to ask the court for additional time, and we're going to have to call a number of witnesses. So, a lot of sort of what we would need to present depends on if the court has concerns about allegations or materials submitted to it other than those addressed in the motion.
Thank you, Mr. Leisher.
Good.
Madam?
Hey, thank you. Your Honor, just so that the record's clear, the parties stipulated to the court looking at this evidence. This wasn't my decision. They had requested it. The evidence was therefore submitted exclusively to the court and wasn't disclosed to the public. The court then thoroughly went through the extensive data for a year and a half and made its ruling. The ruling provided specifics that what I was to disclose. As of today, the no new evidence, I would say that the evidence that the court reviewed, now there may have been difficulty with a couple of the videos, I realize that, but the 4 items that were given to the court, it was given under 101, 198, 107, and 108. And those are the items that the defense had given to us. 101 is, the court reviewed this document, it was a report. And it's under 101 and 102. And we have 1 report and 3 audios. My concern on number 107, I'll come back to this, but Ms. Sheriff asks, have you ever been advised of your rights? She says, yeah. No rights were given. He is talking to his partner Les. As far as charges for her, it sounds like she stole a coat. She's a co-defendant. She wasn't given her Miranda rights.
Is that, I'm forgetting the name, something Longo?
Billy Joe Montalongo.
Okay, so go ahead.
She would have been likely a co-defendant. She admits to doing so prior to Miranda. Miranda is not until after 3 minutes, 26 seconds. I'm going to, with the court's permission, the allegations that were set out, I have a list of the allegations and what evidence sort of supports those allegations. And that came from Ben Anzio. He was the deputy county attorney. He, I believe, is on Zoom. And Max Mueller, who is investigator out of Kansas that Lake County had hired for the purpose of reviewing this. So it was independent from Lake County. And these were sort of the allegations he outlined. If I read those, or?
I'm thinking, again, this is an offer of proof, and I'm getting an idea of what you would intend to show. So
I would intend to show that the different items that fell under the false or misleading reports. I would also intend to show that he made false and misleading statements orally and in writing. I would also intend to show that he was untruthful through the omission of material fact. I would also show that he failed to follow proper procedures in effectuating arrests and issuing Miranda warnings. I would also show that he failed to properly effectuate searches and seizures. I would also show that he failed to properly investigate crimes, including failing to document witness statements and interviews properly. I would also show that he failed to properly secure evidence. I would also show that he failed to cooperate with public officials in the discharge of their authorized duties. And I have the list of items that would show that based on the complaint from Deputy Anslow. And the other video, these were converted. I understand today that Mr. Deputy Malcolm had converted these for the defense. I reviewed the tape 108. It was provided to the court. And although the state didn't convert it because they didn't want to be responsible for converting evidence that I'm just handing over. It shows he asked the trooper, and while they were at 9 Mile, he continues to question Marlon Tonkasen. He asked, did the trooper already advise you of your rights? Did the trooper already advise you of your rights to your understanding rights? No Miranda was relying on his statement. So this was provided, it wasn't, and while he was talking to them, in the reported allegation, prior to speaking with Marlon, Mr. Comfort said, in his report, he says, I advised him of his rights. He didn't. I believe in one of the cases, another trooper, he said, did advise him. That was part of the problem for Lake County. The evidence showed that Lake County kept asking the lead investigator, Brian Funk, to please give us Chad Anderson's report. Apparently, he interviewed this guy, he gave him Miranda, where's his report? No report was ever submitted to Lake County, as far as I'm aware, and I believe that would be the testimony. Also, when asked by the Deputy Lake County, I've already covered that one. He also asked incriminating questions prior to advising him of his rights. He characterized it as small talk. Anything that is meant to elicit incriminating statements, you have to Mirandize. You can't just small talk, or you can't talk around the facts that I'm going to talk about the facts so that they think they're not going to be in trouble, and this person will spill the goods on another person without giving Miranda either. Allegation for number 132, nothing in the reports referred to the use of small talk prior to advising opposites. We didn't even put that in his report. Lake County figured it out after the fact. I know that there was some very big consternation about that case, and it ended up happening during that case. The videos, by the way, I don't know if I covered this. If I did, I'm sorry, I'm repeating myself. But there were multiple videos on your disc. The disc you received was on the disclosure information based on the court's order. And number 68, number 72, number 73, number 67, number 327, number 328, number 329, number 71, and number 100. I believe that we're just rehashing what already has been provided to the court, and I understand that the video may be clear on the converted, and some of the videos I could not open myself. So I realize that may be a difficulty with court as well. But it's been a long haul and a lot of work.
Thank you, Ms. Jackson. So the court is going to grant in part and deny in part the Rule 60B motion for relief. The court is going to vacate that portion of the opinion and order, which is largely from page 7 on, which talks about the Brady material. The court is going to maintain in place the discussion regarding the settlement agreement provision. The court remains steadfast in its understanding of what that confidentiality provision does and doesn't do. I don't think it affects Brady disclosure, and frankly, as a matter of public policy, would need to take a backseat to any Brady disclosure. However, the court does plan to have a future evidentiary hearing regarding what individualized incidences the county attorney believes needs to be affirmatively disclosed. That hearing, because it does contain CJI, criminal justice information, will be a sealed hearing, and portions of the transcript may be opened at a later date, but the court, I think, needs to make very specific findings of fact, conclusions of law, and an order regarding any sort of Brady material. That opinion would be open to the public and would be published so that the public has a fair understanding of what the court believes is Brady or not Brady information. Much like it had an opportunity in the opinion and order, the court addressing the other issues was purposeful in that it would place defendants on notice that if they wanted to go on a boondoggle and look at other issues, they were entitled to do so. But they would have to affirmatively ask for that information from the prosecutor's office. It would not be automatically provided. Now, I will note this. Again, it has been, and I had understood that the parties had asked for the court to determine if certain information should affirmatively be disclosed to defendants, i.e. Brady information. The purpose of this future evidentiary hearing, which the court will schedule here shortly, will be to determine if specific information should be affirmatively disclosed. I note this though, the prosecutor's office always has the duty. The duty resides principally with the state, not with the court. I understand that in close calls and given the factors involved, and the court analyzed one in that it is not a good idea to be accusing any person of a crime without some reasonable suspicion, and certainly charging without probable cause, because that leads to complaints. And I presume that the county attorney's office is not in the business of generating complaints against Missoula County or Mineral County. So I anticipate that would take at least a day. Again, to be very clear, what the court anticipates from that hearing is that the county attorney would go first and would show what incidences the county attorney believes may be subject to affirmative disclosure. It would then be up to Sheriff Funk through counsel to establish why that isn't the case or why they've misapprehended the facts. Again, the court would anticipate that people who were involved in that investigation or key facts would be available. The court is more likely than not to provide significant flexibility in those individuals appearing via Zoom. Key individuals who you will be relying upon their credibility for ought to appear in person. The court would anticipate having this in Mineral County, holding this sealed evidentiary hearing in Mineral County, and then issuing a decision fairly quickly thereafter. Looking ahead, I don't know if the parties have brought their calendars and we can look at when we might be able to schedule it. I would anticipate that the earliest we could schedule it, given the need to perhaps subpoena witnesses and otherwise get prepared for this, would likely need to occur in May. The court would offer Wednesday, May 13th, Friday, May 15th.
Wednesday.
I've got some other dates too, so
Okay.
Let me give you all of the dates I think that the court can make itself available. Friday, May 22nd. Tuesday, May 26th, which would be unfortunately the day after Memorial Day. Friday, June 5th. Any of those days prohibited?
Your Honor, the 13th or the 15th would be best for us.
And, Your Honor, I could possibly do it the 13th, but I have 3 trials.
Justice Court? Yeah.
Justice Court, and I have the scales. So maybe the 26th, if counsel could make it on the 26th. I have the court, but I believe Mr. Compton can fill in for me.
So did you say 13th is available, but 26th is better?
It would be rough, but I could do it. The 26th would be the better option for me.
Mr. Leisher?
Your Honor, sooner is certainly better. The election will be decided in the primary, which is June 2nd. And this, of course, is the central issue in the election. And what the public is most focused on with respect to this race.
Court will then set it for May 13th. We'll begin at 9 a.m. in Mineral County.
Your Honor,
Yes.
if I may, it would be helpful for me to be able to prepare for our evidentiary presentation, if I get the list of the allegations that the county attorney intends to try to establish at some point before the hearing, so that I can.
It's in your discovery. I can point you to it.
So I want to make sure that Mr. Leisher has a fair opportunity to respond to each and every allegation. Mr. Leisher recognizing that there's disclosure of confidential criminal justice information, and recognizing that you are required not to disclose it beyond initial disclosure to you and to Sheriff Funke, and frankly any experts or witnesses that may necessarily be called. I would have that disclosure provided to you no later than April 22nd, which would give you 3 weeks prior to trial.
And Your Honor, some clarity might be helpful. It sounds like from Ms. Jackson's response a moment ago that, and please correct me if I'm wrong, that her sense of the allegation she's going to intend to prove is the entire list of Mr. Eschenbacher's letter, as opposed to individual accusations within there.
Well, and I would have some discussions between the two of you, and I suspect that there are allegations that are more reflective of what Brady Giglio addresses, and others, failing to fill up the coffee pot when you finished it does not arise to Brady Giglio, although it may be office policy or something like that. So again, I want the parties to be focused on the type of Brady Giglio disclosures that a prosecutor necessarily would have to provide, and not on non-law enforcement related activities. And I presume that most of those are related, but there may be, again, breaches of office policy or county policy that have no sounding in Brady Giglio at all and do not reflect upon credibility. I think a good example is the prior order of this court with regard to Deputy Allard, that clearly there's the court again wants to be specifically focused because I don't have time or the inclination to wander down paths related to extraneous information. Let's keep it focused on Brady Giglio disclosure, and then what evidence or information we have. And again, all of that will be subject to the evidentiary process to the greatest extent possible. I realize if witnesses have passed on or something like that, there will need to be some flexibility because the court still has to make a determination. But I do anticipate that individuals will be subject to cross-examination, and we will go through the admission of evidence process like we do with any other exhibit. So hold yourselves to those same standards. That's the standard that the court needs. And again, I wish to create a record that is actually appealable. And I respect and Ms. Jackson, I do appreciate the fact that you provided the court with a lot of documentation. And in fact, that was what caused the court such a lengthy time for review, because the court did review all of that. At this stage, and hindsight being 2020, it's better that we back this up and again go through that evidentiary process to create a record. Given an officer's reputation and future career is at stake. Anything else we need to address?
No, Your Honor. Thank you.
Okay. We will see you on May 13th. We are in recess.